Okay, I had this question asked from multiple directions, so I'm going to ask, and I'm going to answer it, and I'm going to answer it per the federal law that applies to all states. Okay, number one, you got your statute of limitations, and that's 2 years in the mass majority of states. The only two that I'm aware of that have a different statute of limitations with regards to you filing due process in order to recover services for a prior school year period where your child did not receive a free and appropriate public education, meaning that there was substantive damage done, and not necessarily the procedural things. Okay, like it's a big no-no not to have the right number of people at your IEP team, but at the same time, did that procedural error result in damage to your child with regards to them not making tangible, measurable progress? So the law is more focused as far as the courts, the hearing officers, the federal judge, they're far more focused on whether the substance of your child's program has been damaged by those procedural errors or in the development of that IEP itself. The decision to change your child's placement, remove them from the generalized setting. Those kind of things involve the substance of your child's program, whether they were identified correctly, whether they were identified at all as needing an IEP, whether the school system conducted thorough enough evaluations to know exactly what kind of services your child requires per the known science for your child's issues. Okay, all of those things wrap into the development of a substantive IEP. All right, and that's the meat and potatoes. Those are the services. And so if there are violations there, then that's where the denial of a free and appropriate public education comes in. Now, can there be procedural errors? Not enough people on the IEP team, the prior written notice not being. Yes, there can be enough of those mistakes to create damage in your child's program. Okay, and I've seen that. It's happened a lot. And it's not uncommon to have a mixture of both. All right. But please remember to focus on the substance of your child's IEP, and that is the program itself. Now, during this COVID time and these decisions to reopen school and what that looks like, the reason that I am cautioning parents, because it's the substance of your child's program that I'm concerned about primarily, okay, not the procedural aspects right now. That there are many mistakes going on, delaying conducting IEP meetings. I think that there's going to be a little bit of flexibility, even though the feds may have not given waivers in those areas. I think that on a reasonableness standard, I do think that some hearing officers and federal judges are going to cut a little bit slack on some of the procedure. Now, on the substance of it, no, I don't think so. And this is where my wife disagrees with me. She believes that that they're going to adopt, even if it hasn't formally adopted, that some of this stuff will be viewed from a reasonableness standard under this COVID situation. And we don't know yet. We won't know until this sort of evolves. I can see where she's coming from, absolutely, but I also believe it depends on the state. It depends on the nature of the governor's orders. It also depends upon another grouping of factors with regards to your individual school system. Let's say, for example, that they're allowing football practice, cheerleaders, band, and then even some schools allowing for some in-person instruction for, some of the kids with IEPs. Does that cut it? No. Now, why doesn't that cut it? I mean, it can be as good faith as you want it to be, guys. But the good faith standard was that was the distant learning crap, because all schools were closed. So the schools had no option other than distant learning. They could not do in-person therapy and in-person sessions. Third-party service providers, your psychologists, your ABA clinics, your counseling, those weren't open either. So the standard in the spring was different. And yes, the feds came out with their guidance that, it should be based upon, a good faith intent and all this other stuff. Guys, that doesn't exist right now. All right, because there's not a lot of, let me say this. You got to check your governor's orders, and you got to check and read clearly if there's any kind of impediments and obstacles. For example, in New Mexico, the governor just came out with a renewed order or an updated order establishing the schedule for public schools, okay? And in conjunction with that, there's caveats that were put in there to address special education, that even though there's a staggered start for elementary, for middle school, and for high school students, starting at the end of August, right after Labor Day, and then middle school starts, I think, a couple weeks after elementary, and then high school would resume, I think it's the beginning of October. But within that, it is very clearly specified that special education or IEP identified children and others that are deemed high risk, I believe, aren't set under those standards, and that and also the Public Education Department for New Mexico, came out with their reopening guidance specific for special education, and made it very clear that there's no waivers, that they're required to provide a free and appropriate public education. Now, there are some guidance or restrictions within the governor's orders, but that's New Mexico. So you got to take that first, and then you sit there and you got to take your individual school system and say, what is their reopening plan? Because unless the governor has mandated a closure, and they can even do that in pockets. Let's say they have, a hot pocket, not the food, okay? They have a hot area where they have major concerns. A governor can make an order specific for a county, for example, or a region of a state. And at that point, that would change the playing field with regards to the analysis. But you've got to start there first. And there are going to be states, let's say, for example, where the governor has put in there that the county health officials are given more authority through the governor to be able to take action. But you would have to sit there and back that up, to sit there and review what the governor's orders are, to determine whether or not your county health official has that kind of an authority. Okay, but if the schools are open, and not closed, then at that point there are options. And if there are options and there's nothing restricting, then at that point, guys, there's nothing impeding your child's right to a free and appropriate public education. I know it looks impossible. I know it does, and I know that and some of you might be okay with a temporary hybrid or a temporary virtual only. And in the next video, I'm going to discuss that, virtual only and hybrid models, and how that impacts FAPE. Okay, but on this one, I wanted to talk about the difference between those substantive, what a substantive program is, and then I want to talk about your yearly rights. You're given your yearly rights, and you're supposed to be given your yearly rights. And I know that it's a document you're supposed to sign, and it contains rights that explain. I mean, it starts at the conflict. Okay, I wish that the states or the individual school districts would put more positive stuff in the beginning of the yearly rights. But they do the bare minimum of what the federal government requires. And that starts at the conflict. Okay, if consensus is not reached on the IEP team, then at that point, that's what your yearly rights explain. What do you do next? What is the next step if there's a conflict on the IEP team? Well, And I can tell you at that point, you know, it has things like explaining what mediation is, explaining due process, explaining the rules on filing a state complaint, directions in that capacity. With also, it explains attorney fees, for example. And let me, because that was one of the questions, so let me go ahead and address that. And this applies to all 50 states. Because you've been given a carve out as a parent to file due process on behalf of your child, then at that point you are entitled to either file due process and act as your own attorney, which is the Latin is to act pro se. That is the Latin term that we use if you're acting as your own attorney and you've been permitted to by the legislation. And in IDEA, a parent is allowed to act as their own attorney. Now, percentage-wise, I will go ahead and warn that parents historically do not have a good track record, largely because, I'm talking about a track record of success in due process, largely because the school has the benefit of being able to utilize their board attorney. And most of the schools in the states do not use their normal local board attorney. Some will serve double duty, but most schools will have their regular board attorney that does the normal board work, you know, union lawsuits, things of that nature, you know, contracts, and that consumes a lot. That's a lot of work. All right. Now, when it comes to special education in 504, schools will typically farm that out to board attorneys that have an understanding and an expertise in special education law, the same as I do, okay? And I represent parents, and I do not represent schools. There are some attorneys that represent school boards and parents. I mean, you're not allowed to do that. We've been asked to represent some school boards. I mean, I was flattered by the offer, but at the same time, guys, I understand what they were intending to do. I think sort of help raise the bar of understanding for their special education department. But at the same time, I did not want to muddy the water as to my purpose and what I'm here to do. Now, have I trained special education departments? Absolutely. And I'd love to do that. It doesn't bother me to do that. I think it's beneficial. I mean, you know, hell, this group is open for special education administrators and educators. I want to help them understand this from a parent perspective and not from the normal one that they get, which is from a board attorney perspective. We don't have the same perspective. And I can tell you right now, do I think it's more beneficial for a school system to understand the parent perspective when it comes to the analysis of how I and how my team analyzes these IEPs and what goes into determining whether a substantive FAPE has been provided, what it is that we eyeball? Yeah, it doesn't bother me, guys. I'm transparent. If the schools do it better, and if they understand how to do this better, then guys, your child is going to be served better. You know, and please keep in mind that any mediation agreement, any settlement agreement that we put into place relies upon these very people, all the educators, the administrators, to sit there and implement those things. So it is a partnership. I am not an enemy to the public school system. I can disagree with them. I mean, but that's what we do with our family. And I disagree with them frequently. That's my job. But it doesn't mean I dislike them. It doesn't mean that I do not rely upon these same services. I do. My daughter relies upon these services. And I absolutely have high respect for the administrators and the educators and aides that have served my child, because they've done so in a fabulous, miraculous way. So I believe in this process. And so because I believe in it so much, I get passionate about it. Then I get upset when people are making stupid mistakes that, quite frankly, are avoidable, like is going on now. Okay? But with regards to attorney fees, you have every right to get somebody like me involved. Just like the school has a right to go out and get somebody that has a specialty and an understanding in this area as well. Otherwise, it's not really a fair fight, okay, if they just reuse their regular board attorney. Um, you know, there's a lot in special education law. And quite frankly, I don't like it when I am dealing with an attorney that doesn't understand this area and just sort of moonlights in it, because I feel like I'm wasting a lot of the time just trying to coach and explain this what I feel is simple stuff to an attorney that is trying to hide the ball or hide the fact that he or she shouldn't be doing this, and they're trying to wing it. And usually when lawyers try to wing it, they're a-holes, and that's where they try to hide the fact that they don't know what they're doing, is in the emotion and bulldogging and the barking. That doesn't work. So the attorneys that do this, that have an expertise in this area, I have high respect for most of them. Some of them I do not, because the way that they handle in dealing with the delicate nature of dealing with children and public funds, I find absolutely irresponsible and calculated. And I just I find it repugnant. This isn't a place for that kind of law. Go into insurance if you want to sit there, or go into criminal law if you want to do that kind of crap. But, you know, don't do this to where what I'm trying to do is trying to help. I'm not trying to hurt, okay? At the end of the day, the educators are victims in this as well, because they're not being supported by the administration. And please understand that my absolute belief in this law is that it's against administration, really. This law was intended to restrain the abuses, historical abuses against a very vulnerable population by administration, not by teachers. I think teachers have been trying to help. That's their job. But if they don't have the tools, if they don't have the knowledge, if they don't have the support staff, they cannot help our kids. Now, where do you get all of those things? From administration. Okay, and I'm not talking about special education directors. Okay, that is a thankless position. And you know, it's almost like there are some excellent special education directors out there. Now, have I rubbed shoulders with some really evil ones like Cruella de Vil's? Yeah, there's plenty of them, plenty of them. But I don't ever want that to dilute the fact that there are a lot of excellent ones out there that are really, really trying, that are hamstrung, that have their hands tied behind their back, that are absolutely disrespected, not listened to because of the hierarchy within a particular school system, which tends to work autonomously from the state education departments. And so when you have a situation like that, and you have a hierarchy to where the superintendent has all power, which they do, and then distributes it down to where the principals are the next layer, and then they have the special ed director way back here, even though the special ed director controls a huge budget and is responsible to federal law and state oversight law that tends to mirror federal, and the principals are not commanded to understand and be competent in this law, but yet they have the next tier of power to where they can sit there and just not listen to the director at all. That's the common. That's the common. The uncommon is to sit there and have the hierarchy structure of superintendent, special education director, and then principal, because that's how it should. That's how this would work far more smoothly if it worked in that hierarchical structure, but it doesn't. The majority is the principals, and I can tell you the principals are my problem. I mean, superintendents are managers, mainly money managers, and most of them do not believe that special education is a wise financial investment, and that's how they look at it, even though it's not their money, and even though they get paid plenty. they still pass judgment as to where this money, which isn't theirs, needs to be allocated. And it tends to be allocated toward those traditional factors that we all try to scream about. You know, and we tend to sit there and go, oh, you know, we live in such a whatever society. Where do you think this stuff comes from? You know, where these stereotypes, which are very real, guys, there's truth behind stereotypes. All right, including Italian ones. I mean, I'll raise my hand. I mean, I can't tell you how many stereotypes, you know, and I didn't make a big deal about it growing up. You know, I laughed it off. It was funny. But, you know, at the same time, especially before I got married, you know, can I dispute the fact that I really did enjoy tan, laundry, and working out? No. So, I mean, I don't know. So there may be something to be said about stuff like that. But with regards to public education, I see this stereotype just regurgitated, and people can sit there and give lip service to it. But that has a direct impact on how we're cranking out students, regardless of what the noise is out there, you know, as far as destroying hierarchical structures and, you know, perpetuating disenfranchisement. You want to look to see where all that's occurring, just attend a local board meeting, and you'll see that that's where it's perpetuated. And it's being perpetuated now, let's say, for example, in Alabama, to where, you know, some of these big schools, and it's mainly the big schools, and some of them are predominantly minority schools with minority administrators making decisions to close their schools to virtual only. But keep football open, keep cheerleaders practicing, volleyball, cross country, you know. So don't sit there and cry me a river. You know, some of you school systems and some of you educators out there, you know, crying crocodile tears about you know, disenfranchised students, and then you're making a decision to hurt that very population. Because you know who doesn't need your help? Cheerleaders, footballers. You know, they're doing well, you know, because why is that? Because once again, here we go. The hierarchical structure within a high school environment tends to shine on who? The athletes, the cheerleaders, you know, those in other sports. It's the ones further, you know, that aren't getting the accolades, that are the kids that are quiet in the back. Those are the ones primarily. And I'm not saying that you know, the kids playing football, that all of them don't fit into multiple categories. Of course they would. But I'm talking in the whole. All right. So I am, you know, I'm sort of making a little bit of a generalization, but, you know, bear with me on that. I just find it fascinating to sit there and say and give lip service to change, you know. And this is what I do every day. And so all this stuff that's been going on this summer, guys, didn't set well with me, you know, simply because in some ways it was destructive. So you turned a lot of people off. And yeah, I saw people changing their profile, and I saw, you know, I saw images of people kneeling, and, you know, and asking for apologies. Lip service. What have you done substantively, really? Where's that change? So when I see these schools, you know, barking about change, but yet they're going virtual only, when they have the option to come up with a different, harder solution, and they don't do it, just perpetuating the same crap that we've always done, other than the fact that, you know, now we have, you know, more divisions all around us, you know, because we're wanting to blame certain people of certain colors and certain genders and certain preferences. It's ridiculous, how short-sighted we are as a people, that we can't see that the real enemy is all of our governmental institutions, and that doesn't have a color, guys. Doesn't have a color. You can sit there and blame a particular race, a particular ethnicity, a particular gender or preference. You can do it. Doesn't mean you're right. You know, because from my vantage point, dealing with government all the time, I can sit there and tell you definitively where our problems lie, and I can tell you definitively in the number of schools that I go into, in the bunch of different states. It doesn't have a gender, guys, and it doesn't have a race. It doesn't have an ethnicity. It's government. And it's the people within government that are making these decisions. And that is a multi-ethnic, multi-racial, multi-gender. It's all of those people. It's all of us doing this. You can sit there and point fingers at you know, I mean, does it help, really? No, I mean, I guess it can make you feel better, and you know, you can sit there and pat yourself on the back for, you know, either playing the victim or taking responsibility for things that aren't yours to take responsibility for. But I digress. So when it comes to this, to the fee shifting, that's what it's called. So you can get an attorney like me involved, and in that case, depending on how the attorney structures their business, at that point, you know, you would need to come up with retainer. You know, there's a myriad of ways that the fee agreements can be structured. All the way from, in a lot of states, depending on the state you live in, they don't do it the same way that my firm does it. Okay, and I can't pass judgment upon those attorneys. I mean, they have a business to run, and I'm not going to pass judgment on how they run their business. It's just that I do have a different model. Because I believe in this law, and because I believe in this law, then I'm willing to fight for that law in what it's intended to provide. And I believe that it's intended to provide an equal playing field. And I do believe that a parent's right to recover their attorney fees and have their attorney fees paid by the district, I believe it serves two purposes. Number one, it equals the playing field to where the parent can advocate effectively for their child. And the second thing that I think that it does is I think that it's a punishment mechanism to where the school system needs to take account for their actions. And this is administration. Now, they can sit there and lie to parents and go, oh, this takes money away from special education. It does not. Now, why is that? Well, because the law is very specific that they cannot use special education funding to pay attorney fees. The other thing that parents do not understand is that school districts have a pile of money, and I say pile of money, not all of them, but they have money set aside in a fund to pay attorney fees. And, you know, attorneys like me, we're a drop in the bucket, all right? Because school systems also have to pay for for union disputes, all right? And that's employees, that's staff. Also any other legal disputes that are going on. They also pay their board attorneys to attend meetings and to keep track of you, because some of them do that. Before you ever find someone like me, some of you already have a file, and the board attorney is more than aware of who you are and is already advising the school system on what they need to do to, I don't know, resolve the dispute. I want to be positive on some aspects, but some of it is a strategy on how to insulate and indemnify the school district from what might be viewed as an impending due process complaint. And they would be the ones arguing against you and arguing on behalf of the school district's position if you were to file due process and act as your own attorney. But under the law, you're allowed to get somebody like me, and then you're allowed to get your attorney fees paid or recovered. All right, that's if you prevail, which means that there's risk involved for the attorney taking the case. And that's why there's different models. You can do it on contingency, meaning that if the attorney doesn't win, then you don't have to pay. Some attorneys do it that way. And others, that's why they require the retainer up front. And then at that point, during the negotiations, they can try to get your attorney fees back. But I can tell you, in situations like that, schools will sit there and say, well, we'll agree to this and we'll agree to this, but we won't agree to reimburse the attorney fees. And I absolutely find that reprehensible. Now, why do I find that reprehensible? Because raising a special needs child is expensive enough, and most parents do not have expendable income to pay for an attorney to advocate for their child, and especially if it is a justifiable due process complaint to where the school system absolutely failed their child. You want to come out of pocket, $5, $10, $15, $50,000 to fight for what your child was entitled to as a civil right, and then sit there and say, well, you need to absorb that cost and not the school system. Well, the parent wasn't the one that failed. You failed. And so it's not right to sit there, and that's why it's called fee shifting. You're responsible in the outset for those fees, but if you are able to show and prove, then that responsibility for those fees shifts over to the offending party, and that would be the school system, which it should. It absolutely should. Now, what also parents don't understand is every school system has insurance policies, and these insurance policies cover things like due process. And I'm not saying every one of them have these insurance policies, but most of them do. And, you also got to take that into consideration. I think so much of this, though, can be handled by parents without the need of an attorney. I do, depending on the situation. And that's why I have this group, is so that we can raise the bar of understanding so a parent can be a better advocate. But at the same time, there's going to be situations, and plenty of you out there, to where it reaches that point to where you're exhausted. It's been multiple years to where they have failed your child's not progressing. For example, I have so many situations to where, I have kids that are in 6th grade, 7th grade, 8th grade that are still reading at a 3rd grade level. The school knew damn well that the child had not made that transition from learning to read to reading to learn. And you can't not tell me that the teachers along the way in 4th grade, 5th grade, 6th grade did not see that this child was not comprehending what was being instructed. But I sit there and I go back, the child keeps getting older, but yet they are stagnant, right around that 3rd grade, 4th grade reading level. Why is that? Well, because that's where that transition happens from learning to read over to reading to learn, which is a different skill set. Pulling in visualization, pulling in phonemic awareness, fluency, all of those things. And if the child missed those in those early years, they just pass them on. And we don't have a lot of professionals on those later school years on that back end. Most of the expertise in teaching children to read, they're intentionally put and purposefully put in those beginning school years. That's why it's structured like that. But I'm just telling you, as a parent, we have case after case after case where that's what we're dealing with. An 8th grader reading at a 3rd grade level, and then a school goes, well, we're not paying attorney fees. Well, you knew damn well that the child was stagnant. You knew damn well the child wasn't progressing. And you did nothing other than the same swatting at flies and striking at leaves, instead of getting to the root of the problem and instead of removing the carcass. So at that point, yes, I do believe that a parent has every right in the world for recovery of their attorney fees. And, it's a drop in the bucket, guys. But hopefully it becomes a motivator to a school to sit there and do things better. And you can sit there and make those arguments, oh, you're taking away from kids, with attorney fees. I'm not taking away from kids, guys. I'm representing my client, and those parents busted the school doing something they were not supposed to do. And that parent has every right to have their attorney fees recovered and paid for. So I'm not taking from anybody. I am merely representing my client in a justifiable claim for what the school should have been doing. And I'll never apologize for that, because I will represent all of you that might hold that different position. Well, isn't that taking from, because that's the narrative from the school system. But if any of you actually opened the books of some of these schools and where they're hiding money and where they're shoving money and what they're spending money on, and how top heavy their administrative offices are, we have a problem with cronyism. We have a problem with a disparate pay scale with regards to what they're paying people in administration, as opposed to teacher units. They're more than willing to sacrifice aides in order to make sure that their athletic coaches are paid, depending on the school. And I'm talking about paid over their contract teaching amount. I mean, it gets very competitive in some of these schools, let's say in Alabama and Texas, to where they're being paid up there close to what the superintendents are being paid. Some more, if they have a championship program, okay? Where do you think that money comes from? A lot of that comes from Title I money, and a lot of that comes from special education funding. It's just that, so many parents don't pay attention. They just don't pay attention. You guys are clocked out when it comes to what your local school is doing, yet your local school has more governmental overlay and involvement with you than other levels of government. But yet we complain about Trump, who we haven't seen physically, we haven't met, we don't interact with, but yet we sit there and give a pass to the very tyrants in our backyard that happen to sit in board positions, that happen to be superintendents, that have direct control over our children and over our lives with regards to dictating a yearly school schedule that meets all of their needs, not necessarily our communities. But yet you stomach that, you put up with it. You don't get involved, you don't sit there and crack the books open, and yet you have more direct control over what happens with the direction of your public school than you do with what the federal government does. But everybody posts about Trump, everybody posts about Obama, everybody posts about Biden or Clinton, whoever. I'm one of those, very politically active. But it's a passion of mine, along with this. I'm just letting you know that as in the real world, the things that you have less control over or no control over is where people spend so much of their attention, but where government is actually damaging you and damaging your family and damaging your child, or the opposite, being an absolute benefit. Best schools, awesome administration, because you also have it the other way. And that's why people want to move into those communities and out of the bad ones. But those in those bad situations, why aren't you doing something about it? So never feel bad if you are put in a position to where you need to go get an attorney involved, and hopefully you find one that is willing to invest in your child to the point where they're willing to take your case and absorb some risk with regards to the outcome, okay? And not sit there and say, well, I'm going to require this exorbitant, outlandish retainer from you. A lot do. you know, but I believe in this law, so, you know, my firm doesn't. And I believe that you're entitled to recovery of your fees or having those paid. All right, those were the questions I wanted to answer on that, okay? And then I'm going to do another video about, you know, explaining the different plans, okay?